Good evening, and tonight on 60 Minutes, we'll be exploring a fascinating topic. Students at Warrenville High School are participating in the Supreme Court mock trial. While the case might not be real, the students are taking it very seriously. The case deals with Sharon Smith, who was 4 months pregnant. She lived in Austin, Texas, and she went shopping. Unfortunately, she was kidnapped, sexually assaulted, and then murdered by a 16-year-old African-American male, James Walker. When James Walker was placed on trial, he refused a plea bargain and pleaded not guilty. This led to a guilty verdict that sentenced him to death. Now, according to the scenario, his legal team is advising that his constitutional rights were violated. Now, the court has 5 pending questions that they must answer. Was James Walker too young to receive the death penalty? Is a fetus entitled to the same rights as a citizen? Was James Walker's right of privacy violated? Is capital punishment cruel and unusual punishment? And finally, are sentencing guidelines for capital punishment discriminatory against minorities? Jacob Rothstein and Evan Froman are a part of the legal team that is trying to defend James Walker's constitutional rights. Here's what they had to say.
We will be arguing the legality of putting a minor to death. In 2005, Roper v. Simmons, the Supreme Court ruled that it was unconstitutional to put a minor to death. And we will also be arguing the morality of the case, stating that we are a nation of morals and it's just simply unjust to be putting a 16-year-old to death.
When you speak in front of the grand jury, what is your main argument going to be?
My main argument will be whether or not it is moral for the country of the United States to put a 16-year-old to death.
What would you say to the victim's family?
We would say that killing him will not make you feel better, and the death penalty is said to cause deterrence, which is completely untrue. It will actually raise the homicide rate, so this will happen more often if he dies.
I asked these 2 legal geniuses to further clarify their theory that homicides increase if the death penalty is in place. Here's what they had to say.
New York has banned the death penalty in 2004. Crimes that would have previously been punishable by capital punishment have decreased significantly.
Also, states with the death penalty have a 50 to 100% increased rate of homicide.
That is a tough argument to beat, but Jake Levine and the rest of the Period 2 prosecution team believes that they have a shot against Period 3. However, when I asked Jake about the entire process of working with the rest of his lawyers and researching on how to defend James Walker, here's what he had to say.
It's not fun.
Interesting. It seems that Period 2 is not as confident as Period 3 with their argument. Here is what else Jake Levine had to say. Can you explain to me why you believe that the death penalty should be allowed?
Since 16 years old, even though he might be considered a minor, he still had complete control over his mind. His confidence of his actions, he knew what he was doing, and he still acted to go through with the murder, and he killed the mother and her fetus.
Mr. Levine, what would you have to say to James Walker in this case?
That, he needs to pay up for his actions. He committed a murder, he murdered this young lady and an unborn baby, and now he has to pay consequences for it. I believe a minor is just a label that we know people under the age of 18. Like I said before, he still knew what he was doing. He continued with the murder and he killed this young lady, and now he has to pay up for it. We can't just say, oh, this is a minor, that you let him go or give him an easier punishment. You have to, execute him to the fullest extent of the law.
Jake Levine and the rest of his legal team may want to start worrying because Evan Froman has made a confident, bold statement regarding his team.
This is a clear-cut case. We will win. It is simply immoral to put someone to death at this young age, especially with all the discrimination that happens in the South with the death penalty. As you will see, this is a clear-cut, open-shut case.
I hope you enjoyed our program, and coming soon, a video will be posted about the trial itself. This is John Case, signing off.